wanted to take a brief moment to ask our panelists for their key takeaways or their final thoughts. Cleve, you led us off this afternoon. Perhaps you want to be the first to close us out with a few of your final thoughts.
Yeah, sure, happy to do so. So hopefully a theme sort of resounding through this presentation is that developing a reliable, reasonable royalty opinion requires a pretty detailed analysis and detailed evidence, and perhaps this seems obvious, but I've certainly observed in my career that how the damages case unfolds depends very much on marshaling the most relevant and compelling facts for that analysis. And I was just thinking about where we were involved in two litigations that involved the same plaintiff, same defendant, and same patent. However, the cases were handled by two different law firms, and we were engaged at or near the end of fact discovery in both of those cases. So we were in the fairly unusual position of seeing discovery in two different cases that one would have thought would be very similar, but when we started digging through the materials, the differences were striking. In one, we had a very rich understanding of the use of the technology by the defendant, meetings, the emails, the debates about non-infringing alternatives, et cetera. And in the other case, most of that information was pretty much absent. So, granted, we're talking here about two different products using the technology. So, the discovery would be different to some extent, but the differences that we were seeing were pretty striking. So, and not surprisingly, in the case with the richer set of information, I think the report that we ended up with there was much more comprehensive and compelling than the one where we didn't have nearly as much insight.
Thank you so much. And Larry, a couple of final thoughts from yourself as well, please.
As a former licensing professional and patent owner myself, the market approach is obviously a very useful approach to use in determining a reasonable royalty from my standpoint. As I mentioned earlier, in real life licensing negotiations, your prospective licensee is always going to ask what have others paid for the use of this technology. And for that reason, you as a damages expert, you should definitely investigate fully all of the market evidence that is available to you to help inform that reasonable royalty.